Stand ready for the second case of this session, which is 24-1673, Mathias versus the State of Iowa. For the appellant, James Mathias, we have the attorney Robert Breckenridge, and for the State of Iowa, we have Anna Dixit. Mr. Breckenridge, whenever you're ready.
May it please the court, counsel. I am Robert Breckenridge. I do represent Mr. Mathias in his claim in post-conviction relief that the counsel that he had for his original trial were ineffective in failing to raise the constitutional argument that the application of 724.4b violated his Second Amendment rights to bear arms. The case is...
I hate to jump in right at the beginning, but the way that you frame the issue raises a question for me. It looks like in the district court proceedings, the issue is presented kind of as a direct constitutional claim and not within the ineffective assistance of counsel framework. Would you agree with that? And if that's correct, can we review what you're raising on appeal?
No, I would not agree with that, Your Honor. Specifically in the second supplemental application filed on February 13th of 2024, the attorney at that time submitted the claim that the prosecution of this offense under 724.4b did violate the Second Amendment of the Constitution. So while that was initially put in there, that's the first time that issue was ever raised. It was not raised. I'm probably not being very articulate here, but we're not arguing that the post-conviction counsel were ineffective. We're arguing that the original trial counsel were ineffective and denied him a fair trial, and that the PCR judge should have found that to be the case and ordered him a new trial where he could have raised those issues in front of the district court.
Right. But what I'm saying is it looks like the district court didn't decide it as an ineffective assistance claim, that it decided it on the merits of the constitutional claim. And you're...
Yes.
Okay, thank you.
Up on Judge Bading's question then, is that problematic for us then, since we don't have that actual ineffective assistance ruling to review? We have just kind of the underlying core of the, I guess, was it worth raising the freestanding constitutional claim?
You could argue that the district court in the PCR did kind of address the ineffective assistance counsel claim, because they talk about the idea that if you have a claim that has no merit, then you're not under any obligation to raise that claim, thereby kind of cutting off the idea that since there is no merit to the argument that this violates the Second Amendment, they can't be ineffective. As the court is well aware, the facts of this case are somewhat unique. Mr. Mathias is exercising his First Amendment right, putting out flyers onto windshields. He is approached by an off-duty police officer who asks him what he's doing. He explains. During that conversation, somehow he raises his arms or does something Mr. Mathias does, and a bulge is discovered. And that bulge is then questioned by the officer. Is that a gun? To which Mr. Mathias says, yes, it is. Here's my permit, and shows him a lawful permit to carry. Now, this is not a school ground in our opinion, but the Iowa Supreme Court has said that under their decision, that the athletic complex owned by the district and its contiguous parking lot does constitute the kind of prohibited area or sensitive area that should not allow for a firearm to be included under the provisions of 724.4b. We would argue that expands unreasonably the idea of what constitutes a sensitive area. Specifically, Sensitive areas historically, as we cited in our brief, talk about buildings. They don't talk about contiguous grounds. But even if you concede that it's contiguous grounds, as Justice Mansfield did in his dissent on that original Mathis case, you still have to limit the scope of your denial of the Second Amendment protections to those that are absolutely necessary. The example that I would give this court is the statute provisions under 724.32. That is the use of firearms, the ability to carry firearms in a courthouse. Most of our courthouses, of course, are multi-facilities. They house not only the court offices, but they house the treasurer and the recorder and the auditor's office. And yet that provision specifically provides that a judicial issuance that firearms are prohibited can only be to those areas of the courtroom, the court offices, and those related grounds. And the reason for that, if you read the statutory language in that particular bill, talks about those are areas of conflict, that the court itself is an area of conflict, and therefore we have to be extra careful, and it would qualify as a sensitive area. In this case, the parking lot of an athletic complex several miles from the nearest school should not be allowed to expand that provision to cover all of that unless we're going to look at whether or not it is a reasonable infringement on Mr. Mathis's lawful opportunity to carry a firearm.
If we reach the merits and we're trying to determine what sensitive places are, and I think that originated with Heller, so what's the time frame that we look at? Are we looking at 2008 when that's mentioned in Heller? Are we looking back at 1791? What's the tradition? What's the point in time?
If you look at the New York Rifle and Pistol Association case, they talk about historical. And they're not talking about 20th century. They're talking about 18th century, 19th century provisions are what you look at, and you look for that historical analog. The problem that we have in the ruling by the district court in the PCR is that judge says on page 9 of that report, of his ruling, that since the Supreme Court has determined that the Brady Athletic Complex constitutes grounds of a school, there is no need for this court to find an historical analog. And that goes in direct conflict to what New York Rifle talks about, what Heller talks about. All of those reasons are we have two tests under Heller-McDonald. We look first for the plain reading of the Second Amendment, and then we look for historical analogs. And in this particular case, we would argue that the only historical analogs that are there talk about buildings, not about grounds, and certainly limit the use of sensitive places. We would also argue that if this court reaches the merits and determines that it was a valid argument that should have been raised, and that it has merit, then that would clearly make the failure to do that ineffective assistance to counsel, which is what essentially you were limited to arguing in a post-conviction relief.
We look at as a reasonable attorney in the trial counsel's position in this case. What do we make of the timing of the fact that Bruin came down, I think maybe 4 years after the conviction?
Certainly changes in the law I would concede, would render how we view an attorney's actions, what he does at that particular time. I don't think there's any way around that. If the law changes, then the standard of practice changes. And so I guess we would concede that. If there are no other questions, then I'll reserve the balance of my time.
Good afternoon, and may it please the court. Your Honors, this case should not be decided on constitutional grounds. It shouldn't be decided on a Bruin analysis. It shouldn't be decided on the definition of a sensitive place or the definition of a school. This case should begin and end with error preservation. The three issues that were raised by PCR counsel, and I did just take another look at that PCR application that was filed in February of 2020, raised three distinct issues. The first was a claim of prosecutorial misconduct. The second was a claim of ineffective assistance of counsel, but restricted to two particular issues. First, a failure to object to that earlier referenced prosecutorial misconduct. And second, a failure to object that the statute was vague and overly broad. The third issue raised by PCR counsel is a, on its face, attack of the constitutionality of that statute under the Second Amendment.
Court reached that freestanding constitutional claim on the Second Amendment, but didn't decide the prosecutorial misconduct claim because it was not raised as ineffective assistance. What do we make of that there is a ruling on the actual constitutional claim?
So the prosecutorial misconduct claim, the PCR district court states it is reviewed if there is some reason given that it wasn't raised on direct appeal. And because it is so closely incorporated in that ineffective assistance of counsel claim, it just addressed it wholesale within the ineffective assistance of counsel. Nowhere in the briefing or the application or at the PCR trial do they talk about why that prosecutorial misconduct issue wasn't raised on direct appeal. So the trial court's, the PCR court's decision not to address that and just address it in ineffective assistance of counsel makes sense in that context. What it didn't do and what it couldn't do was make a ruling on the ineffective assistance of counsel for failing to challenge that statute under Second Amendment. That is how this issue has been put before you. And it isn't just a question of form over substance because the standards are different. It matters. It matters how it's presented to you. It matters that there is nothing in the record that explains why the attorney at the trial level made the decision to not raise a Second Amendment challenge in that context. It matters because how we approach an ineffective assistance of counsel case, breaking down that duty and prejudice, is different than how we would review the constitutionality of a statute. And if this court decides to reach the merits, we're still successful regardless of the path that you choose. If you decide an ineffective assistance of counsel claim is preserved, then what you're doing is looking at the duty the attorney had in 2018, 4 years before Bruin came, under the previous interpretation of many courts for the Heller-McDonald structure. It was not the traditional analog, the historical analog. It was a means-end evaluation. So holding an attorney to a standard where he now has the duty to look into a crystal ball and predict what the cases are going to look like 4 years from then is an unreasonable standard to hold an attorney to. And if we're looking at prejudice, we still succeed whether we're looking at this case under the Heller standard as it was kind of previously looked at, or we're looking at it under the Bruin standard as it changed. Under both of those cases, schools were considered these sensitive places. And Mathias, the Supreme Court, has already defined this as school grounds of a school.
And if we were to reach that step of the analysis, is there some room for us to say, well, schools are sensitive places, but since school grounds may sort of expand on that, the PCR district court should have kind of made a separate analysis about that sports complex?
I would say there are two answers to that. The first is that the Supreme Court, in defining kind of the grounds of school or school grounds, equated, how the statute was interpreting the word school as school grounds or grounds of a school. So to that end, the kind of equivalence has already been made. The second answer to that would be that the PCR court actually did address this issue. And it did say that Bruin is not read so narrowly, it cites Rahimi in doing that, it's not read so narrowly that we only have to consider school as the physical structure. And there's cases that we cite in our brief from Montana, Virginia, Texas. There's a Maryland case called Kipke v. Moore. There's a US v. Benson from Pennsylvania. All of these cases talk about outside structures, parking lots, athletic facilities, and they're saying that those constitute schools under that definition of what is considered a sensitive place. So it's not like there isn't case law to support the idea that an athletic structure would constitute a school. We have the Supreme Court telling us that, we have the PCR court telling us that, and we've got case law telling us that. So on prejudice grounds, the issue fails. On a direct attack against the constitutionality of the statute, it fails. On an attack of ineffective assistance of counsel, this fails. The only question before you today is, was this properly preserved for your review as an ineffective assistance of counsel claim? And the answer just has to be no.
Point, if on appeal the appellate issue had been, did the district court err in finding no constitutional violation, would that have been properly before us?
It would have been properly before you because the PCR court ruled upon it. They would have still been unsuccessful because even if we do that prejudice analysis or that
A problem because it was a new ground of law?
it would have been an 822 A problem, I believe, because it was a challenge to the constitutionality of that statute.
Do you know of any case law that would suggest that, despite the two standards, that if a constitutional issue is embedded in a PCR, you don't need to flesh them out in terms of error preservation? In other words, if you find that it's not unconstitutional, you don't need to reach a PCR. Excuse me, I meant ineffective assistance of counsel.
If we find that there isn't an ineffective assistance of counsel, then we don't need to reach the constitutionality claim.
Inextricably linked, as counsel suggests.
I'm not aware of any case law that kind of equates that in such a broad way. I would say that the PCR court reviewed and delivered on the issues that had been raised and put before it. And that's the problem, is that in questioning the attorney, they don't talk about any constitutional challenges. They don't talk about, why didn't you talk about the Second Amendment? They're not piercing into his thought process at all about why these challenges weren't raised. And so we have no record to make those kinds of determinations. And even if we did on the prejudice prong, it would fail. So, when we're looking at error preservation, the state prevails. When we're looking at, was there a duty, even if we did reach ineffective assistance of counsel, the state prevails. If we're looking at prejudice, the state prevails. There is no avenue here under which the appellant can succeed. And for those reasons, we would ask you to affirm. Thank you.
Would you reply?
Briefly, Your Honor, the counsel for the appellee indicates that the trial defense counsel at the PCR level did not flesh out or raise the reasons for his direct challenge to the Second Amendment. And I would differ with that. The brief of the defendant, filed on 8/21 of 2024, sets out a complete argument for the fact that the Second Amendment does apply in this particular case, should have been used by trial defense counsel as a grounds for excusing his conduct, Mr. Mathias's conduct at the time. They talk about, they cite all the relevant cases that we've talked about here today, and then he adds additional cases in a notice of additional cases in which he talks about those ideas of what constitutes a sensitive place and does not. And we would argue that the trial court did address those issues, specifically when they talked about and made the declaration that we don't have to come up with the historical analog. And when the court then also talked about the rash of school shootings, basically dragging us back to the means ends test that was set aside by the Bruin case. Now, yes, this case was originally decided back in 2020. and Bruin's decision was in 2022. So that is an argument that is a problem in terms of error preservation. We admit that. But we believe that it was sufficiently preserved when you look at the other cases such as Heller and McDonald, that we could go for, that the trial court should have gone forward and made a direct determination of whether or not this violated the Second Amendment or not.
The Iowa Supreme Court's decision in State versus Woods from June that upheld a conviction for carrying weapons while in possession of controlled substances against a Bruin challenge. Does that have any impact on the merits of your argument?
I can't answer that, Your Honor. Sorry, I'm not familiar enough with Woods to give you an intelligent response. Thank you, that's all I have.
Thank you both for your briefing and your responsive arguments today. We will consider Mathias versus State submitted, and we'll have a written decision as soon as we can. Thank you.